A discharge without conviction application is available to anyone as of right. However, it's usually reserved for those with no criminal history and is a high but not insurmountable threshold to reach. Before entertaining the idea of advancing such an application, I shall advise you on the strength of the grounds you are raising to determine whether it is something worth pursuing. The court will not grant a discharge without conviction unless the presiding judge or community magistrate is satisfied that the direct and indirect consequences of a conviction for you are out of all proportion to the gravity of the offence. Essentially, the court balances the seriousness of the charge and a conviction of the same for you against what consequences will occur for you in the real world. Some traffic charges have a greater likelihood of success than others. For example, it's important not to understate how seriously the courts and police view drink driving offences. For that reason, their gravity often already begins at a moderately serious level, meaning the consequences need to be very high to succeed. Youth is often a factor that assists with drink driving charges, that being if you're 24 years old or under. But youth in of itself does not necessarily guarantee success. More is required. If you're considering the merits of a discharge without conviction application, get in touch with me to discuss it further. I'll provide my candid views on the likelihood of success, not to dishearten you, but to ensure that you're not spending time and money on a fruitless endeavour.